Good afternoon. Thank you for joining us today. We have a wonderful speaker and one of her colleagues from her firm who will be speaking with us. It's Aubrey Knatzer and Becca Shapiro. And these two individuals have been lifelong, as long as I've been with DVAP, have been very responsive to mentoring our attorneys who take cases in family law, and we are so blessed to have them and to have them continue to be committed to DVAT. Aubrey has her own law firm. She was previously with other big name law firms here in Dallas, and she has risen to the top on her own with all of her staff, and we are so proud of her. She has been named on every single attorney award in Texas that you can count. We are so blessed to have her, and I'm going to let her take over. I'd be here all day reading her bio but I know you're here to hear about everything, but you have the best person to mentor you today. Thank you.
Oh, Catherine, thank you so much. And thanks for having me. I'm thrilled that there's so many folks interested in hearing about kind of the basics of child custody and child support and family law cases. I hope that means every one of you either has or will take a case from DVAP that involve family law issues. Thank you, Becca, my associate, who did put together a little PowerPoint for us today so that you can actually see the statutes and read some of them for yourself about some of the high points I'm going to hit with what's involved in child custody and child support issues in a family law case. Certainly, typically, there's not as much property to divide in a DVAP family law case as there would be in some other cases because they've qualified for pro bono services. So that will not be the emphasis today, even though, of course, if there are any specific questions at the end and there's time permitting, I'm happy to help anybody that needs it on those types of issues. As Kathy said, I've never done anything but family law. I don't know anything but family law, but I've done it for a minute, and it's one of, I think, the most rewarding types of law to practice if you've got the gut for it. Sometimes it can be pretty gut-wrenching when you're fighting and arguing over people's family, their children, their life's work, but at the same time, it's a higher risk, higher reward segment of our profession. It's an honor and a privilege to serve our courts in that way, because I know our family law courts always appreciate having attorneys who are competent and able to help clients who otherwise might be pro se navigate that system in a way that's going to be more efficient for the court to keep its docket moving, especially when so many court dockets are backlogged with a lot of pro se litigants. So if Becca will start our PowerPoint, I want to start with the child custody piece and sort of basics of a family law case. When you're either in what's called a SAPS, or a suit affecting the parent-child relationship, which means you are kind of arguing over either children of a relationship that was never a marital relationship, or you're dealing with a modification of conservatorship and possession, maybe support as well. It does not necessarily involve divorce, but could involve just a modification. But even if it is a divorce and involves children, you have to deal with the conservatorship issue. Of course, all of those statutes are set forth in our family code, and the overarching theme and theory in Texas is that as long as both parents can act in the best interest of a child, then they are presumed to be named what are called joint managing conservators. There are two types of conservators: joint or sole, with the other parent being a possessory conservator. And a court must, under Chapter 153, appoint either a joint or sole managing conservator in every case involving a child. So those are your two buckets, your two possible buckets in an agreed order or in a hearing to ask for. Um, there are certain nuances with regard to that umbrella of sole versus joint that include things like considering family violence or parental involvement or location. You might have an absent parent who doesn't live close by. But in general, most of your cases are going to have two parents, and they're going to need to be appointed either a sole managing conservator, with the other being what's called possessory, or joint managing conservators who share rights and duties with regard to children. The managing conservator, if one is appointed, has to be a parent, competent adult, or the Department of Family and Protective Services, or a child placement agency. So it is possible in some cases, and I've seen these come through DVAP every now and then, that a grandparent, for example, could be named a managing conservator of a grandchild. The last pro bono case I did involved some grandparents who wanted conservatorship over their granddaughter because their son was a meth addict. And the baby had been born with some birth defects because the son's or the child's mother also had some drug issues and likely used drugs during the pregnancy. And so we ended up succeeding on that endeavor and having both grandparents named as the managing conservators of the child, primarily so they could get medical care for the child and have the legal right to make those decisions because the parents were both absent. But regardless, there are options. It doesn't have to just be a parent who's named a managing conservator of a child. When the court makes the selection of conservators, they do have to consider whether family violence has been present, if there's a protective order that's been filed or rendered against one or the other party, and there's some kind of outcome determinative issues that surround the topic of family violence. If there has been family violence, I always think when you are doing intake or initial conversations with your client, you need to ask about those things because you certainly don't want to go to court and say we're fine with joint managing conservatorship, and then later you hear about gruesome, horrible family violence that should have been brought up at the outset. 153.004 talks about how to navigate the issue of domestic violence when appointing conservators. The court may not appoint a person who has a finding of family violence against them as a joint managing conservator. That's kind of a short way of saying what this statute says. So unfortunately, sometimes in my practice, I see folks make allegations of family violence against one or the other parent as a way to do an end run or backdoor entree to foreclosing joint managing conservatorship. Reason being, if they can get a domestic violence finding or a family violence finding, they know that they will get exclusive rights as a sole managing conservator, as opposed to having to share rights in one way, shape, or form as a joint managing conservator. So family violence or sexual abuse certainly needs to be asked about with regard to not just the conservatorship issue, but also whether or not, pursuant to 153, Chapter 153, if the possession schedule should be limited with that parent because of the abuse. One hot topic in what we do on a daily basis is sort of the dichotomy between a violent relationship between parents or conservators. They may not be spouses, but they may be just parents. Sometimes it's dating violence and not interspousal violence if they're not married. And the distinction between actually committing acts of violence against children. Some courts differ in their opinion about, what they will rule with regard to a specific case and kids who may have witnessed violence against their parent by the other versus children who've actually been victims of the violence themselves. Some courts are more inclined to say, look, if the violence was between the parents and now the parents are not together, we don't think the children are at risk. And so we're going to proceed with a possession schedule that's not limited, but maybe grant a protective order in favor of one of the parents, but not the children. Whereas other courts may hear facts or evidence that lead them to believe the children are in danger, regardless of the fact that the violence wasn't aimed at them. One theory that, I think plenty of people have proven in specific cases is that it can be just as traumatizing to witness violence from one parent to the other, and you feel the same intimidation and fear of the parent who's been violent against your other parent without ever being touched. And then yet another under that umbrella is that perhaps when the other parent isn't there to be a buffer, that there might be a higher likelihood that violence could be perpetuated against the children absent the other parent being present. So all of those things are factors to kind of be mindful or at play, and also realize that it's a rebuttable presumption that joint managing conservatorship is not in the best interest of children when there has been a history of domestic violence. A lot of times you factor in the circumstances of the violence, the length of the pattern of violence potentially, but certainly a threshold issue when you're issue spotting in your cases to be mindful of and ask some questions about on the front end as opposed to the back end. Becca, you can move to the next slide. There you go. When there are conservatorship appointments, the court must specify rights and duties of parents who are appointed as conservators. When there is a sole managing conservator appointed, there are certain exclusive rights that go to that sole managing conservator. However, when you're a joint managing conservator, there are lots of options, and in the context of a case that you might be handling, you can also agree to specific rights and duties to be independent, joint, or exclusive to one parent, which are really the three options. I don't tend to love independent rights, just as I've seen in my practice, unless you have really effectively a sole managing conservator who's managing most of the decisions of a child and a very uninvolved possessory conservator. Sometimes a court will give independent rights, knowing that practically that means I need to let the one that's in charge and on the ground, the boots on the ground, make the decisions without having to consult or have a written agreement from the other parent, because that other parent may withhold consent. However, it's not a strong enough dichotomy to award exclusive rights to one parent versus the other. But independent rights literally mean if I have an independent right to make a decision about a child and my ex-spouse also has the independent right to make the decision, that I can sign that child up for therapy with Susie Q Therapist in Plano and take the child, and yet the other parent can sign up the same child for therapy with, John Therapist in Garland and take the child, and the child gets no continuity of care. And that's usually my argument against independent rights when I'm put to that task, is that it really does potentially jeopardize continuity of care for a child if both parents might actually, or both conservators might actually exercise an independent right in that way. Joint rights, subject to the agreement of the other parent, which is usually how we verbalize them in the divorce decree, mean, you cannot make the big ones we call are ed, med, and head, which is educational, medical, and psychological and psychiatric. And those are the three, like we say, the biggies that are the ones that are fought over most. There are other rights that are less controversial, like rights to services and earnings of the child. I mean, unless you have a child star that's making a bunch of money, you're never going to have to exercise that right or worry about it. Another is rights with regard to allowing a child to enlist in the armed forces before they're 18 or marry before they're 18. I don't know that I've ever litigated that issue in 25 years, but with regard to consent to medical, psychiatric, and psychological and educational, we really have to pay attention to whether these rights are joint, independent, or exclusive. If they're joint, you must agree on a therapist. You must agree on psychiatric medication. You must agree on the school that they attend. And that oftentimes in a joint managing conservatorship arrangement is a good check and balance if you have two good involved parents. The problem is when you can't quite agree, then who makes the decision? So sometimes you have to think about if they're joint subject to the agreement, do you put somebody in as a default, like they agree to have the pediatrician make the decision, or they agree that whoever designates the primary residence of the child will dictate the public school system that they are enrolled in. Typically, that's what the designation of the primary conservator entails, is choice of school. Under the joint managing versus sole managing conservatorship dichotomy, clearly the sole managing conservator has exclusive rights that include designating the primary residence of the child. We call that kind of the primary parent. And that usually ties into possession schedule, which we will get into in a minute. But the primary parent typically has more possession of the child than the non-primary joint managing conservator. Whereas if you're a sole managing conservator, you obviously designate their primary residence and have sole rights with regard to the big ones and the little ones. One other potentially controversial issue to address with regard to rights and duties is passport. Who has the right to apply for a passport, renew the passport, and who gets to keep the passport in their possession? Sometimes if you have clients who might go out of the country to visit family or need a passport for a child in order to stay connected with the family, going back and forth across foreign borders, you really need to be sure that you address specifically passport language for the children. We have in the family law practice manual, which if you're taking a DVAP case, I hope they would help provide you, and I would too if you needed it, just the typical family law practice manual forms for things like passport language in a decree that talk about if you're going to use the passport, here's how you use it, here's how you renew it. If you have the sole right to renew the child's passport, there is a form with the passport office that can be used that allows one parent to apply and renew a passport without the other parent's signature because they have a court order giving them the exclusive right to do that. That can be really, really important if you have a parent from another nation who needs to go visit a sick grandparent or care for someone. And if they don't have the right to renew their child's passport and the ex or the other conservator refuses to sign or provide consent, then you've got to file a motion with the court to modify or force a signature. But the family law practice manual language and forms are extremely helpful to make sure you have kind of a belt and suspenders baked into the decree about who gets to do it without having to go back to court to modify. And one thing I always like to tell my clients when a case comes to conclusion, especially if it's a divorce and you've entered into these orders for kids, particularly, I hope I never see you again, because I hope that I've made your decree in such a way that it gives you the ability to navigate the world with your kids without having to file a lawsuit every time there's a disagreement. So it's just something to think ahead about when you're taking a case. If that's going to be an issue, you want to make sure that you get provisions baked into the decree that help your client longer term with regard to those issues. Okay, next we have the possession and access schedules. There's been a little bit of recent, I don't want to call it upheaval, but change in the law with regard to possession and access. Family Codes, Chapter 153 is the statute to go to when you want to look at what the options are and what the law says. The court must, it's a shall in 153 specify in a standard possession order that the parties can have possession at times mutually agreed to in advance by the parties and in the absence of an agreement under the terms specified in the standard possession order. There is a presumption that if both parents can act in the best interest of children and be joint managing conservators, which they usually are, that the standard possession schedule is in the best interest of children. Now, that obviously can be modified, but the standard possession schedule in the family code has some different benchmarks based on how far parents live from one another. And so I usually put, and I think it's prudent to put multiple possession schedules in your decree. If you live from 0 to 50 miles apart, if you live from 50 to 100 miles apart, or if you live over 100 miles apart, meaning the two conservators. The typical standard possession schedule for parents who reside with between 0 and 50 miles apart includes what we used to call expanded standard possession schedule with dismissal times for pickup at the end of school and return times back to school the following school day. Used to, we had to always elect whether we wanted to pick up at school and return to school. But if you live within 50 miles of one another now, you actually automatically get expanded standard, which is after school on Thursday, back to school on Friday, after school on Friday, back to school on Monday on your first, third, and fifth weekends if you're not the primary parent, if you're either the possessory or the non-primary joint managing conservator. If you live between 50 to 100 miles apart, if the parties do, then that automatic or default is old standard. And what old standard is what most people think standard possession is, at least in my experience, which is every other weekend from Friday to Sunday, Friday at 6 to Sunday at 6, and then a dinner during the week, which used to be on Wednesday night from 6 to 8 during the school year, and now is Thursday night from 6 to 8 during the school year. However, if you live less than 100 but more than 50 miles apart, you have the automatic election to say, no, I want to pick them up at school and return them to school, not do the 6 o'clock to 8 and then the 6 o'clock to 6 on the weekends. You also have the option not only to elect the pickup and drop off times, but you can also, between 50 and 100 miles, elect to take Thursday overnight to Friday back to school and then Friday to Monday for your weekends. In the off week, when you don't have the weekend, if you're not the primary conservator, you still get the option of the 6 to 8 dinner time on Thursday night or the overnight on Thursday from after school on Thursday back to school on Friday. There's just a little more built-in flexibility that I think the legislature and the foundation and lobbying for the change in the statute thought would be better to, instead of just saying from 0 to 100 miles is one schedule and over 100 miles is another, to give a little bit of leeway for parents who, I mean, if you live 50 miles away from your kids, that's a long way. 75 miles is certainly a long way. 100 miles gets you to Waco. I mean, so, and with a 60 square mile county, being Dallas County, it can really think about how long it would take you to get from South Dallas to Plano in rush hour. So from that perspective, I think that's a good change in the statute, that it does give a little bit more of a sliding scale for possession. It can be a little hard to digest and think about. So what I do for clients usually is I do a pink and blue calendar. You know, if mom and dad are the two conservators, and one's primary and one's not non-primary, I give them a calendar with pink squares and blue squares to show what it looks like to have the expanded standard possession schedule with pickup and delivery from school to school versus regular old standard, to let them see what that practically looks like. Of course, as the prior two slides said, you know, if they agree to something, the court's going to approve anything parties agree to with regard to possession and access. A lot of parents agree to 50-50 possession and access, which can look a lot of different ways, like a week on, week off, or what we call a 2-2-5, which is where one parent gets Monday and Tuesday, the other parent gets Wednesday and Thursday, and then they alternate the Friday, Saturday, Sunday piece every other week. Some people think that's not good for their kids. It's too much back and forth. And it's too much not, you know, knowing where you're going to be which weekend, but others really like it. The standard possession schedule does give more, in my opinion, predictability with regard to, you know, one parent gets the first, the third, and the fifth weekend of the month. And you can look at a calendar in 2027 and 2037 and know what the first, third, and fifth weekends of the month are. If you're alternating weeks or if you're alternating weekends, you got to count backwards or forward from the date of the decree on for an every other. And then you've got to deal with, does the every other reset for holidays or not, and try to manage that. But it just depends on what the preference of the parties are. If there's an agreement to work around these schedules, then that is always, almost always, in my opinion, approved by the court. If you live over 100 miles, the same possession schedule that's kind of always been in place applies, which is 42 days in the summer, 42 days in the summer, and holidays, which are standard. So standard holidays include Mother's Day for moms, Father's Day weekend for fathers, every other Christmas, every other Thanksgiving, every other spring break. But because the over 100-mile access gives you more limited weekend time, it really is just Friday at 6 to Sunday at 6 on your weekends that are first, third, and fifth weekends of the month. Or at your election, you can pick whichever weekend of the month with notice to the other parent that you want if you just want one weekend. We usually see first, third, and fifth more frequently exercised for parents who live in Dallas versus, Dallas and Waco, North Dallas and South Waco, that are a little bit over 100 miles apart than we do parents that live an airplane ride away. So if a kiddo has a dad in Cincinnati and a mom in Dallas, dad may elect one weekend a month that he's either going to come here or that he's going to fly the child out to him in order to exercise that one weekend a month during the school year. But because you have theoretically less possession time during the school year, given the distance of the parents' residences, you get a little more time in the summer, and that's 42 days versus 30 days that a possessory conservator or a non-primary joint managing conservator gets in the summer typically. Now, when you look at the holiday possession that's unaffected by distance, those are assigned to parents on an even odd year schedule. So primary parent may get even spring breaks and odd Thanksgivings. If you get Thanksgiving week under a possession order, the way the even odds work out, then you don't get what the first half of Christmas. Christmas is always split under the standard possession order on the 28th of December. So one parent gets dismissal from school for the holiday until the 28th of December. And then the other parent gets the 28th of December until the return to school. And sometimes that's a even Steven trade. It's not always, depending on when Christmas falls and New Year's and all that. But for a long time, the swap off date was noon on the 26th. And it just turned out to be a little too hard to swap possession the day after Christmas all the time. And so they extended it to the 28th because that tended, based on most school calendars, to make it more even during the longer winter break or holiday break. So if mom has Thanksgiving, then mom is not going to have Christmas Day. So mom will have the second half of the winter break. If mom doesn't have Thanksgiving, then mom will get the first half of Christmas break, which will include Christmas Eve and Christmas Day. And that is always negotiable because some families have long-standing Thanksgiving traditions with one side of the family and long-standing Christmas traditions with another side of the family. And I've had plenty of clients say, every Thanksgiving should be with these grandparents and parents, and every Christmas should be with that side of the family, and they can agree to it because that's what they have always done. And others like the every other, so that you cannot miss every Christmas with your kiddo, the rest of their minority. Or other parents are very flexible and say Christmas is when we have Christmas, and it can be any day during December or January, and we'll do it when we're together, and it doesn't have to be on the 25th. And so sometimes it's good to ask your client, how important is the actual day to you? How much flexibility do you have? Because I do find in cases frequently, holidays can be a real hot button for people. They can be very sentimental to one parent and not as sentimental to another. And so sometimes that's a really easy negotiation tool and leverage point if you're trying to get something else for your client, like extra weekend time or extra summer time or something else, but be willing to give up Christmas every year because it's not much of a give if you get every Thanksgiving. And again, any agreements between the parties, I can almost assure you will be approved by the court. The other holidays that you can see in the list, as I said, Father's Day and Mother's Day. The other thing that the code contemplates is the child's birthday. If the child's birthday falls on possession time with one parent, the other parent has the right to have the child for dinner, 6 to 8 p.m., as long as that parent picks them up from the residence of the parent who has possession and returns them to the same place. This is an issue to watch for and to make sure. I mean, if you're going to star anything in this, not anything, but one thing in this presentation, I'd make sure that you try to remember in every family law case where you have a possession schedule, know when the kid's birthdays are. What if the kid's birthday is in July? Well, the 30-day summer possession default is July 1 to 31. So if somebody doesn't elect their summer possession with notice to say what 30 days they want, they're going to get July 1 to 31. If that child's birthday is in July, they're not going to be able to be out of town or go stay with grandma in Louisiana or wherever for that 30 days because they're going to have to be available for a 6 to 8 dinner time to the other parent during that possession time. Sometimes it's not a big deal if your child has a September birthday or a April birthday when there aren't otherwise holiday possession periods in place. But if you have, like my daughter has an almost Thanksgiving birthday, and if there's a birthday that falls over a holiday, you have to be real careful of that provision that whatever parent has possession of that child must surrender that child at their home or residence and to the other parent for that optional dinner for 2 hours. So it would be really bad if you always go to Cincinnati for Christmas but you live in Dallas and you have to produce your child to the other parent from 6 to 8 on their birthday that's on December 23rd. So just a really, in order to file a petition, you have to know the birth dates of the children. So just pay attention to that so that there isn't a misstep, or revise the birthday possession language to say something that works for the family. That if it's during a family vacation, it'll be rescheduled and one parent has the right to do that, or some flexible language is good when those birthdays fall kind of in hot times. The primary parent for summer possession, which I've dabbled in a little, but I want to close the loop on. When your client is selecting their summer time with a child, they've got to give notice by a certain day. Usually it's April 1st and April 15th. And the non-primary parent elects by April 1st. And when they do that, they have to tell you what their 30 days are and what 30 days they choose that can't interfere with the other parent's Father's or Mother's Day plans. And they can do it in different intervals, but they can't just pick 3 days at a time. So you elect your time knowing that the primary parent can give notice by a certain date to trump a weekend during the 30 days the children are with the non-primary parent. So easy example is, let's say they choose July 1 to 31. Mom's going to have the kids July 1 to 31. She's not the primary parent. Dad's the primary parent. Dad has the right to elect a Friday at 6 to Sunday at 6 during those 30 days that he gets possession of the kids, so that no kid goes without seeing their parent for 30 days straight. On top of that election to trump a weekend during the summer possession, the primary parent gets to trump a weekend during the summer outside of the summer possession, which means they get basically a 3-week period to be uninterrupted, to be with the children, to entitle them to travel or have a vacation or send them to camp or send them to grandma's for camp, for granny camp, which my kids always love to do in the summer, get rid of me. So just be mindful of those dates, that those are explicit in your decree. And again, the family law practice manual language has all those default dates in it when you're drafting a decree. And make sure that your client realizes, when the deadlines are, such that they don't unless they're okay with the default. Some people intentionally don't notify because they're fine with July 1 to 31 every year. But just a word to the wise on that. And then with regard to general terms and conditions on this slide, there are also very standard provisions in the code with regard to who picks up and returns the child, under what circumstances. Sometimes it can read like a real snoozer, and it's hard for some lay people to read and understand. So, make sure you understand what the rules are with regard to who picks up when. Do you pick up at the primary parent's house? Do you return them to the house? Things are a lot easier under the standard possession expanded schedule that has the election time of two school to school pickup and drop off, because it's real easy to pick up and drop off at school and not have to go to the other parent's house. But for the most part, if there is a possession time that must begin when the child's at a parent's home and not school, or end at that time, typically you're going to see that the non-primary parent is doing most of the travel. That is one thing that you could try to help your client out a little bit in negotiating terms for pickup and delivery, and maybe share the pickup and delivery. If I pick up, you drop off. And the best way to do that is to make sure that whoever is getting possession of the child has the burden to pick them up, because a lot of times people will not drop off when they're ordered to drop off. And it's harder to figure out where they are. But when you're ordered to surrender a child at your house and the other one has the onus to pick up, it tends to flow a little bit easier and delineate more clearly whose burden it is to start their possession. So that's just a little practice tip that I like to use. All right, Becca, let's go to the next one. This is, alternate beginning and ending possession times. Those are the times that you pick up and deliver either at school, back to school, or 6 p.m. on whatever day. But there are codified provisions for who picks up when for holiday possession, Mother's Day, Father's Day, Thanksgiving, and weekend possession. There's also provisions with regard in 153 with regard to weekends extended by a holiday. So we just had Labor Day. That's a great one. It's usually it's the first weekend. So whoever has the first weekend, their possession is extended from the Monday return to school to the Tuesday return to school. So that if your weekend happens to fall as mom or dad on a holiday weekend, you can go travel to the lake, or you can go travel to grandma's house, as the case may be, and enjoy the entire long weekend with your children, as opposed to having to come back and turn them back over to the other parent. Let's see. We talked about the alternative beginning and ending times, and the 50-mile language. And so we'll move now to child support. Hot topic in every case, whether it's pro bono or not. We get a lot of questions about child support and what the rules are. On Monday, the child support guideline amounts changed. And so it's actually a very hot topic right now, an important thing for everybody to know who's handling pro bono cases. Child support is payable for a child until the child's 18, or an adult, or graduates from high school, whichever is later, or until the child is emancipated through marriage or operation of law in another way, or until the child dies, which is typically super unpleasant, but certainly a important piece of the family code, that if you do have a death of a child, obviously your child support obligation terminates. If the child is disabled and is disabled prior to the entry of the court order, then that child is entitled, or the other parent is entitled to support for the child until the disability is removed. Meaning, horrible example, but what if you had a child who had cancer and they were diagnosed with cancer at 17 and were in ongoing treatment post 18 and graduation from high school? That child would be eligible for child support beyond 18 until maybe they're clear of cancer. If you have a child with a permanent disability that requires additional child support, and you can prove what those numbers are, then the disability may never be removed. I mean, obviously there are families who unfortunately suffer the fate of having children who are permanently disabled. Well, those children are entitled to permanent child support from both parents until forever, potentially. The family code also authorizes judges to set aside and order life insurance to secure child support obligations. I'm not sure that any cases we'd be taking from DVAP would have the level of assets to enable that. But if there's even a small policy with an employer, that can be by court order pledged as security for a child support obligation, particularly in the event of a child who has extended eligibility for child support based on a lifelong disability or a disability. When child support is ordered, the sometimes we have a fight over, oh, well, are you just going to keep your kid in school and they're going to repeat 6 grades in order to elongate the payment of child support? Theoretically, yes. We don't really see that that often. Most courts order the manner of payment under 154 to be one of these 6 possibilities that are listed on slide 25. Usually it's periodic payments, meaning monthly or per paycheck, especially if it's withheld from a parent's paycheck. They can also, some you may or may not know, order lump sum child support payments under the right circumstance. You pay X dollars now and you don't pay any more. The purchase of an annuity, which I rarely would come up, I think, in a DVAP case, but could. They can set aside child support. Set aside property to be administered for the child. This is in a case where there may be a trust of some sort, or much less likely retirement or other employee benefits that might be available, or any combination of the top 5. But 99 times out of 100, you're going to see periodic payments awarded or to the obligor, meaning he's got to pay on the first of the month every month, or however often he is paid via wage withholding order. The payment of child support is required by statute to go through the state disbursement unit. So the Attorney General's office has a state disbursement unit that manages child support. There are all sorts of mechanisms for utilizing, I think, in a very good way, the state child support registry for the child support disbursement unit, such that the parent receiving child support can set up an account to have their payment automatically deposited into their account each month. With wage withholding, if a child support obligor is ordered to pay via wage withholding order, it's automatically debited from their paycheck and deposited into their account with the state. And the state keeps track of what's been paid versus what's owed, and what may be in arrears, potentially, if someone stops paying. But it's a third-party agency that manages those things. And in a lot of cases, what happens is if there's an enforcement that needs to be filed for lack of payment, you can go through the state disbursement office and the Attorney General's office to file that enforcement, as opposed to having to hire a private lawyer. I find that often, child support enforcements are very cost prohibitive, because if you're paying a lawyer to enforce child support, oftentimes the lawyer's hourly rate is more expensive than the amount in arrears, and it's cost prohibitive. Doing a pro bono enforcement, on the other hand, of child support, is a much better financial deal for the obligee who's not getting paid. But in the real world, where everybody doesn't have pro bono representation, it can be a tough thing to achieve. The court will sign a wage withholding order if asked, to enforce child support and make sure it's withheld from the obligor's income, which again is extremely useful. But at some point, when the child is emancipated under some of the 154 factors, the income withholding order must be terminated. And so you do need to show the child has been emancipated, the birthday, and inform the employer that the wage withholding order is suspended by virtue of the emancipation of the child, or if the child is deceased, or if the child marries or enlists in the armed forces. The withholding order can also include medical support, which we'll get to at the very, very end, because a standard possession schedule with a primary parent and a non-primary, or a managing conservator versus a possessory conservator, must include provisions for support of the child. And not only is the obligor going to be ordered to pay child support, but also to provide medical support in the form of health insurance premiums, and then 50% typically of the uncovered expenses of healthcare. So copays for medicines or doctor visits, whatever that uncovered expense might be. So in the income withholding order, you would not just include the monthly child support, you would also could include the monthly medical support amount if the primary parent is covering the insurance. And so medical support can be one of two ways. Either the obligee is providing the health insurance and getting reimbursed by the obligor, or the obligor provides the insurance directly and then reimburses just the 50% of the uncovered medical between whichever parent is paying. But most courts are going to require that an income withholding order be signed at the time the divorce decree or final order is entered, because if it's not signed then, it's usually not going to happen. And I've certainly seen judges, so also put this in your knowledge bank for a practice tip. If you're doing a pro bono case, make sure you know whether a withholding order is going to be required. It usually is. And realize that you may be turned away at the courthouse if you don't have one. Again, the Family Law Practice Manual has forms for all of those things. One thing that a lot of people will ask is, particularly in cases where there might be a 50-50 possession schedule, is, oh, well, I have 50-50, so I don't have to pay child support, right? And the code, we've heard that for so many years, that the code actually has a section to address that issue, meaning they cannot condition support on possession and access. So if somebody doesn't use their possession or access of a child, they can't say, well, if you don't use it, you have to pay more support, or if you do use it, you may not have to pay support, or if you have a 50-50, nobody pays support. That the amount is a case-by-case basis. And I do find that most courts, even in a 50-50 possession schedule, will order support by one parent to the other. Sometimes what a court will do is look at what would dad pay mom if dad were paying, and what would mom pay dad under the sliding scale if mom were paying, and then net it out and make whoever would pay more pay the difference to the parent who's not otherwise receiving. But sometimes and frequently I see with 50-50 possession schedules, a court still order guideline child support. Let's see. To calculate child support, that's the new calculation and the max guideline amount that we've seen go into place on Monday of this year. You have to arrive at your client's, if your client is paying or receiving, you got to look at the obligor's net resources. And Chapter 154 has a laundry list of what it includes and what it doesn't include. So when you're talking to your client about how much child support they're going to either be entitled to or how much they're going to have to pay, you absolutely need to reference 154.062 of the Family Code to see what that list includes, and importantly, what it doesn't include. There is also a family law section toolkit that is produced every year that I feel sure DVAP has a copy of, and I certainly do, and could share the charts that are in there with regard to how to calculate net resources and what the sliding scale numbers are with regard to child support amount, which we'll get to, I think is in the next slide. There we go. So there is like I said, a sliding scale. For one child, the obligor pays 20% of their net resources up to net resources of $11,700, which is up from $9,000 and some change before September 1 of this year. For two children, it's not double, it's 25%. And for three, it's 30%, going up in 5% increments for additional children. The theory being that part of what your child support payment goes to is overall household expense. So the mortgage, the lights, the bills, the electric, the water, which doesn't significantly change based on the number of children you have. Your mortgage is the same whether you've got 2 in college and 1 at home, or 3 at home and none in college. And so that's why it's the theory of why it's a sliding scale, and it only goes up incrementally based on the number of children you have, but it also goes down incrementally when those children who are the oldest emancipate. So you may be paid for 3 children, 30% of your net resources, up to net resources of $11,700 until the first one emancipates. Then it will be 25% until the second one emancipates. And then it's still 20% while you still have 1 kiddo at home. And a lot of people have a hard time with that, clients, that is. I don't believe the lawyers would have a hard time with understanding it at all. But that's the theory with regard to not doubling and tripling the amount, but doing a sliding scale. And I think we have those percentages maybe on the next page. Yeah. So if you have a low income child support guideline, because their monthly net resources are less than $1,000, then they do apply a smaller percentage to the net monthly resources of 15, 20, 25, 30, 35 as the number of children go up, as opposed to, well, as it shows on the top of 33, 20, 25, 30, 35, and 40%. So just something to be aware of. And again, the family law section toolkit has all of these calculations in it pretty summarily and easy to digest. And so does my office, if anybody needs help with that. I talked a little bit about medical and dental support. They are long, arduous statutes to read. They, they read like an insurance policy, a medical insurance policy. So they're not fun reads, but the basic premise for medical and dental support is that the non-primary parent covers the premiums and the parents split the uncovered. But dental support is also included in that when dental, and mainly because dental support is required now under the code. And I think that is the end. We have a few minutes. I'm sorry I talked so long. I was going to try to leave 10 minutes for questions, but if anybody has any questions, I'm happy to answer.
Thank you, Aubrey, for that wonderful presentation. I believe there's some feedback. Perfect.
Hey.
Thank you. I don't see any questions in the Q&A box, but if you do have questions, please feel free to enter those at the bottom of your screen. Please self-report your MCLE course credit through your State Bar of Texas profile using the following course code. That code will also be emailed to attendees following today's presentation. So don't worry if you do not have that. See, I still don't see any questions in the Q&A, which is completely fine.
If anybody wants a copy of the PowerPoint, obviously I'm happy to share that. I can probably share that through you, I guess.
Yes. And I can email that out to attendees.
Great. And also feel free to email me directly if you have a question or a specific case, question that you don't want to share on the more public platform. I'm happy to help in any way I can. It's important we have lawyers taking these cases and continuing to help those that can't afford legal services for hire. So I'm happy to support in that way. If you're on the fence about taking a case but need some help, then feel free to reach out to my office.
So thank you so much, Aubrey. Thank you everyone for attending this afternoon. And we give you the last 2 minutes of the noon hour. If any questions do arise, please feel free to reach out to me directly. And happy to answer any questions. We wish everyone a good rest of their afternoon. Thanks, Aubrey.
Thank you.
Bye, everyone.